Hello, my name is Walker White, Chief Executive Officer of Oliver Technology Corporation. Thank you for joining today's session. In this short video, we're going to discuss how organizations can increase effectiveness today and prepare for tomorrow by leveraging a modern litigation strategy. We'll also hear from both the U.S. Bank and one of their collections law firms who have done this, as well as learn a bit about the Oliver solution. Before we jump in, let's spend some time talking about why we got into this business, what opportunities we saw, outline the critical failure points that creditors, debt buyers, and law firms are currently experiencing, and propose a different perspective that will increase efficiency today and prepare you for the future. The collections market is currently experiencing the first credit cycle in the CFPB era. In 2020, according to the St. Louis Federal Reserve, consumers will default on at least 2.3% of outstanding debt, costing creditors over $325 billion. And collections professionals will find themselves trying to recoup that loss. However, there are many competing forces pulling on collections professionals. First, the volume of charge-offs is rising or is expected to rise dramatically. Yet, given the nature of the current downturn, creditors wish to provide more flexibility to consumers. At the same time, the downturn not only affects consumers, but businesses as well. Thus, many collections teams are being asked to do the same and often do more with less resources. And finally, as the first credit cycle since the CFPB era, compliance has everyone under a microscope, taxing resources even further. This is an incredibly difficult situation for a collections professional. It feels like you're in a hole that you can't get out of. However, as was made famous by Will Rogers, everyone knows the number one rule of holes, which is to stop digging. So, how does the current environment impact your current litigation strategy? Well, we know that litigation is the most effective strategy, often liquidating debt at 4 to 6 times other strategies. But you're experiencing or expecting volumes that are making it difficult to scale. Most organizations already have more suit-worthy files than they can pursue, and that number won't be decreasing. Second, the burden of compliance has already increased, and given market conditions, will likely become even more cumbersome as we move forward. Also, as noted, the current environment not only impacts consumers, but businesses as well, thus budgets are shrinking. And in the meantime, you need to manage communication and changing processes across all your channels. But it's a very manual process that is consuming your resources and leaving you vulnerable to compliance and reputational risk. So we ask you to imagine a different situation. What if you could cut costs, accelerate the litigation process, and increase revenue at the same time? How would that help you keep the lights on today and still prepare for the future? And, by the way, provide an almost immediate ROI. An effective litigation strategy creates a well-oiled machine as files move through stages from selection and pre-placement to contested litigation and post-judgment remedies, and they do that efficiently, cost-effectively, and fairly. But most collections litigation strategies are difficult to scale cost-effectively while meeting compliance requirements. Most strategies are not built with the agility that's needed to manage the changing dynamics of the market, and we call these failure points. Each time you hit a failure point, you leak value out of your strategy, and this has a direct impact on your bottom line. We have broken down the collections litigation strategy into 5 stages. Within each of those stages, we identify common failure points that are leaking value from an operational, compliance, and management oversight perspective. However, you don't need to take our word for it. We are pleased to present a Q&A session with Heidi Stallo, Assistant General Counsel of U.S. Bank, and Thomas Michael Jr., Managing Member of Lawgix Lawyers LLC. In this session, you'll get a glimpse into how these two organizations determined they needed to retool their litigation strategy and how that is preparing them for the effects of COVID-19 and beyond. So let's listen in. Heidi, you were tasked when you came to U.S. Bank from the collections litigation side, a collections law firm, and when you got there, you were tasked with building a cost-effective, compliant litigation strategy. Could you talk a little bit about the challenges that you encountered when you started looking at solutions that could satisfy both your cost-effective and compliant requirements?
Sure. Yesterday, I think when we had our brief session, I talked a little bit about how the bank, there wasn't a lot of software on the bank side from accreditors, and that was a surprise to me because we had a lot of options from the law firm side. But today, I kind of wanted to go into a piece that I didn't talk about as much, is that compliant piece that you're talking about in the state and local law. From the law firm side, that was naturally built into our processes, and as trained lawyers and paralegals in a firm, we had some of that expertise. That doesn't exist necessarily inside the bank, and certainly not at a national stage. So needing 50 states worth of laws. So the other piece that I found missing, thinking of it now from a creditor side, was how do we build in all of those laws? Because otherwise we have all of this training that we have to do and testing, when really it's a very, it's a technical piece, and we can build that into software just like law firms have or do in their processes, so that we can trust that and then get to be managing more performance and not down to that level, as well as just things that are issues, whether they're from our from consent orders or just from something different, like that, and wanting to build those different pieces that are choice and not necessarily required by federal or state law.
Great, thank you. So Tom, on the other side of that coin, obviously you were working with U.S. Bank as a collections firm. You're basically on the other side of that. So what was your perspective on the solutions that were out there, both from a cost-effective and building a cost-effective and compliant litigation strategy?
So we had the same like legacy type products available that Heidi had mentioned. I think for us, what we were looking for is something that was a lot more robust in the ability to encapsulate the the requirements of each state that we were working in, and really push down our operational costs by capturing that institutional knowledge. The way I mentioned, law firms have institutional knowledge because we're lawyers and paralegals, and we just know how a particular state works. So we were really struggling to find a scalable way to implement all of that institutional knowledge into a platform, so that we could rely on the platform more heavily than relying on training people. Our particular plans were requiring us to scale up the number of states that we were going to be operating in very, very rapidly. For context, we went from 2 to 10 states in the course of 12 months. So that is just a massive undertaking from an operational perspective, and we needed something that would let us lean on technology much more heavily than we were able to in other solutions, and also to scale the technology much faster than we could have with other solutions.
Okay. Heidi, back to you. From the creditor perspective, what are the 3 things that you found most valuable about the Oliver CLX solution in, to your goals are compliance and cost effectiveness? What did that translate to from a product perspective? What were those if you had to pick 3 things?
So I think in addition to how the Oliver platform builds in at that state level and the way that we want to interpret that law, you guys aren't deciding it. I get to, we lawyers get to provide our input into there and have it work the way we want. And so, and test to that. So I think that agility to be able, as laws change, and to be able to modify that in there is something that's super helpful for us. I think from a cost-effective standpoint, that goes into 2 things. One, in just all the automation means we need less people in order to do the job. Also, from an FTE standpoint, in training, it's internal costs that we have. that we have less that we need to train our employees on because it's built into the platform. So there's a cost effective state on both of those. And then the compliance, I think I've touched on a little bit, but I think the other piece that was huge for us is transparency. Right now, the way that creditors are set up to audit, it seems a little odd to me. We rely on reports that our law firm gives us to tell us that they're doing a good job. So while we trust that they're giving us, honest, good information, it's sort of like asking the person you're testing to tell you if they're doing it right. And so what I really like about the CLX platform is that it gives us all transparency. We're working collaboratively in the same thing. We can see what's going on together and find that out, and hopefully nip some problems in the bud. You should have good relationships with your firm, so it's not about that, but it's that way you can solve problems. Is it a problem on our side or your side, and kind of get right to it, and kind of cut out the delay in finding problems through an audit that happens on a quarterly basis and things like that. Right. So I think that transparency and the timeliness of it helps you be better together.
Right. So that transparency is really allowing you to collaborate better with them, subsequently moving the files faster, bringing the revenue in faster.
Yeah.
Wonderful.
Yeah.
So Tom, I think it's really interesting to see the same question on two sides of the coin, but from the collections firm perspective, what do you see as the three most important benefits that Oliver CLX brought to this?
Sure. So not surprisingly, there's a lot of overlap with what is valuable to the bank is valuable to us. As a collection firm, all law firms are concerned with efficiency, or probably should be, but collection firms in particular, that efficiency of motion, the efficiency of the effort that you put into each file is incredibly important when, your revenue opportunity for a file is, constrained to however many dollars you can make per matter. And so one of the things that we just hated dealing with before the Oliver platform was client updates. We would get emails or phone calls, mostly emails from clients all the time, just simply wanting an update, like, hey, what's up with this file? And you spend 2 or 3, 5 minutes, 10 minutes going in and finding the information and putting an email together. And it's client facing, so it's not something you can just slap together without thought. And that just drains efficiency out of your firm. You spend so much time every week just telling people what's going on, and that's not time that you're spent moving files forward. So that was just prior to the platform, one of our biggest headaches that we had. And so the Oliver platform to us really kind of helps us take a lot of the manual effort out of the motion. So consolidating all the data into the same place so that we don't have to go get this data and bring this batch in and move the, remember to scrub these things or remember to do that, so that there's much more consolidated information. Everything we need to know is in one place, and by and large, it's brought there for us. We don't have to do anything. And then orchestrating our process for us. We know that in this state, here's our procedure. We do this for so many days, and then when that point in time is ready, the file moves on, and we're not manually making sure that files move through the process. They're moving through for us and being presented to our staff, whether it's attorney or support staff, at the point in time which is most valuable for action. So we're able to just rely on that orchestration across a big footprint. Like I said, we scaled our footprint pretty significantly. And so, huge amount of value in the ability to take a small team of people and put them at the very most valuable points in time for every matter is just, incredibly important. And, ultimately that means that we can litigate collection files for our clients across, a big footprint, and do it as efficiently as possible from a staff perspective. So that's where the value is to us.
Right.
We measure attorney to staff ratio, and it's significantly less than the average collection firm. So that's
right.
That's great. So look, last question to both of you, and kind of watching our 15-minute timeline here. Here at the event, we've obviously heard a lot about COVID-19, its impact on collections in general, and in some cases, some entities, potentially pausing litigation. Can you each give me your kind of take on the market and litigation as an approach in this kind of post-COVID-19 world, and how do you think Oliver will help you in that context? And either one of you can go first.
Heidi, go ahead. I think
Maybe I was gonna let you go first today, since I jumped on the final question yesterday. I think as we're looking at trying to figure out what our, when we get back to litigating, we're kind of on the cusp of that. It's not business as usual. It is at least as it was prior to COVID. And I think we had this hope that we were just going to take this pause, and then once we could get going, it was just going to be turning on that same button. And I think it's not. Our COVID is here to stay. We're going to need a COVID response plan. We're going to need to figure out how we need to adjust to our customers. We're very customer centric at the bank. So different than maybe other on the creditor side, from an originating creditor side, we are. So I think being able to work with our software company to help us make those changes that we need and have that be, again, built in. So if it's that we want outreach letters, if it's that we want a certain impact, if it's that if a customer calls in and says this word and we note it, it triggers a different response for us. And I don't have to rely on the agent taking the call to then alert all the triggers. It should happen automatically. So I think for us, the beauty of this is that ability to pivot and address a problem that we didn't anticipate, and be able to put us back, into litigation in a way that we can do it in the environment our country is in.
Fantastic. So the agility, basically, of kind of putting these changes into the platform, allowing to adjust for new laws, rules, and procedures that may come down from the state, federal, even the local level as it relates to
and even our position on a settlement, or our position that we can build in, and we may have a certain authority, but it may change if somebody says three things, or they give this, and that can be built in, and it doesn't require additional permissions from the bank. We can put that right into the technology so that our firm can immediately respond and not and resolve that for the customer on that same phone call.
Got it. Tom, your perspective, again, other side of the fence.
I think, in going through this, the last few months with all of our clients, but in particular with Heidi and US Bank and their team, it's just really put more emphasis on the partnership between the creditor and their servicers, their law firms, and the ability to collaborate. That for these banks, there's nothing stopping collection litigation from going forward in most places at this time, or if there is, it's really probably not going to be in place for very much longer. So it really becomes about the creditor's unique exposure to risk from like a headline perspective and a reputational perspective, and their ability to work with partner firms and collaborate with them and really see the absolute detail down to the file of exactly what's going on. We've been able to work with the bank throughout this to just turn on a dime, really, our operation for them, and then give them the peace of mind of being able to log in and see every file, where it is, what's been moving on it, or more importantly, what hasn't moved on it. Being able to show that, no, we didn't send a G notice out on this file, and they can see that and follow it up with, data and reporting. I think it's just been incredibly helpful. And as the environment continues to just put more and more pressure on the collaboration and the partnership between creditors and their firms, I think that this technology is going to be much more, helpful.
Yeah, and I know we're out of time, Walker, but the other point I want to say is, like, during this hold, we've been able to keep some of our work productivity up and tee things up so that when we are able to get out of it, it's not that we have months of backlog. So we've been able to have work product waiting and to get out. So we've been able to manage the hold in a way because of the way the platform works, and your agility to be able to put things in a delay, for us, that we can get work ready to go. So when we are in a position, I feel like we're set up much better than many other than many others to get going.
Right. So, how can Oliver help? Well, let's start with the big picture. Oliver is a collections litigation platform that consolidates and orchestrates the repetitive regulatory and legal processes to deliver increased revenue, rigorous compliance, and simplified litigation. We do this by breaking the litigation strategy into 3 distinct work streams: consolidate, orchestrate, and litigate. The consolidate work stream centralizes all the data pertinent to a matter, bringing together and creating a litigation master record. The orchestrate work stream automates collaboration. Through our unique compliance framework, we ensure that all federal, state, local, and even venue-specific laws, rules, and procedures are followed. In the litigate phase, we accelerate litigation and accelerate collections, providing unprecedented visibility across the entire litigation channel. The value of Oliver falls into 3 areas. First, increasing revenue. Oliver increases revenue by driving more files down the pipe rather than trying to adjust the returns on any given file. By automating and orchestrating these repetitive manual tasks, Oliver is able to increase throughput by 6 to 7 times with the same number of people. In rigorous compliance, Oliver codifies federal, state, local, and even venue-specific laws, rules, and procedures, ensuring that all files are processed compliantly. And finally, we simplify the litigation process. We drive collaboration, communication, and oversight by securely bringing all parties together to be able to easily share information securely about matters. As a next step, we would encourage you to request a demo where, in a short 30 minutes, you could learn how you reduce your costs today and accelerate results tomorrow. Just fill out the form below if you'd like to request a demo. We'd love to hear from you. While you're there, you might download the U.S. Bank profile to learn more about how U.S. Bank was successful with Oliver. Thank you very much for your time today, and if you have any questions, please feel free to reach out to us.